Thank you for joining us. I think it's been a fascinating ride. I think all of us, if we weren't intimately aware of Harvard's actions back in a few years back, we all certainly had questions about the broader impact, as well as sort of what they really were trying to say by eliminating single gender or forbidding people from joining single gender organizations. That said, I'm going to turn it over to Bob for the remainder of the session, and he'll introduce our guests. I'll let him set the ground rules as far as questions. I do encourage you to keep it on mute. You can ask questions certainly through the chat feature. And this session is being recorded, so be careful what you say about your roommates. And with that, Bob, I'll let you take over.
Thank you, Dan. The Harvard sanctions against single-sex organizations was largely the creation of two Cornellians. Dean of Harvard College, Rakesh Khurana, Cornell class of 1989, and William F. Lee, who graduated from the Cornell Law School with me in the class of 1976. Harvard sought to extend its jurisdiction to off-campus organizations such as fraternities, sororities, and finals clubs. Under the sanctions, starting with the class of 2021, members of single-sex organizations were ineligible for serving as team captains, leaders of other student organizations, or being nominated for Rhodes Scholarships or other similar programs. It applied equally to all male and all female organizations. The plan engendered two legal challenges, and Harvard, at the end of June, withdrew those sanctions and abandoned the plan. And I think it implicates far more than just the question of single-sex organizations. It also goes to this very strange Rube Goldberg device of punishing individuals just because they happen to be members of organizations that conduct policies that are different with Harvard's administration. So I think it has a lot to teach us at Cornell in terms of how far things can be taken. We are very lucky to have with us to discuss the end of the Harvard sanctions, Zach Greenberg, who is a program officer with the Individual Rights Defense Program at the Foundation for Individual Rights in Education, FIRE, and Clark Brown, who's General Counsel of the North American Interfraternity Conference. So I'm going to first call on each of them for probably about 5 to 10 minutes to talk about this, and then I will pose a couple of questions, and then we'll open up to the audience for their questions. So Zach, the floor is yours.
Yeah, sure. Thank you, Robert, for organizing this event, and thanks everyone for coming. Like Robert said, I'm Zach Greenberg. I'm with the Foundation for Individual Rights Education, otherwise known as FIRE. FIRE is a nonpartisan, nonprofit organization that defends students' rights and free speech on college campuses. We defend the free speech, freedom of association, due process, legal equality, religious liberty, and the essential qualities of liberty on American universities and colleges. I'm part of the Individual Rights Defense Program, and we primarily engage in direct advocacy on behalf of students and professors who've had their rights violated. One of my specialties at FIRE is dealing with fraternities and universities and freedom of association issues. At SUNY Binghamton, my alma mater, I founded the Pi Kappa Alpha chapter, proudly a founding father, and I can use my perspective to help out other fraternities and students that are trying to get their universities recognize their rights and to generally defend their freedoms at these places of education. One thing that I try to do at FIRE is educate university general counsels, administrators, students, and faculty members about their rights, because we believe that to be forewarned is forearmed. A lot of the fraternity members I run into, sometimes they choose to not to fight back, not to vindicate their rights. And what I say is that by standing up for your rights, just defending the rights of everybody. By asserting your freedoms, you're really helping all the students at your university to vindicate their rights when the time comes when they're threatened. And I'm really happy to be here to speak with all of you, and I look forward to talking more about the Harvard decision and answering any questions you may have. Back to you, Robert.
Well, how about your opening ideas there, Clark?
Sure. Thank you very much for having me. Appreciate that. My name is Clark Brown, the General Counsel for the North American Interfraternity Conference. The conference is a trade association that represents about a little more than 60 men's national fraternities. And we are one of our primary endeavors is advocacy, both legal advocacy and advocacy in federal and state government relations. So we were in the early kind of, I was going to say square one, but probably square zero involved with bringing the lawsuits against Harvard when we sort of helped form and provide a lot of the infrastructure to the coalition of fraternities, sororities, and final clubs that brought suit against Harvard and supported the litigation, both with time and with money and with power of thought. So it has been a long road. I think Robert teed up some of the issues very well. I will tell you that the sanctions policy started off as a targeted only to men, and then when I guess somebody in Harvard General Counsel's office told Dean of the college, Khurana, that he likely had an illegal draft policy on his hands, they changed the policy to include women's organizations. And when women's undergraduates at Harvard complained about their inclusion in the loss of their women's only organizations, those organizations and those women were unfortunately referred to as collateral damage of the policy. Those words came back to haunt Harvard in court papers, and I think they will probably haunt them for decades to come. So the case is not over. I want to just update everybody just so we understand what the current procedural posture of the case is. There are two separate lawsuits. There are lawsuits that primarily involve sorority plaintiffs pending in Massachusetts state court, and there's a lawsuit pending in federal court in the District of Massachusetts that primarily involve fraternity plaintiffs. They have slightly different legal claims in each, but the heart of each lawsuit is the attack on the sanctions policy that has now been withdrawn. So to sort of illustrate how the case is continuing in federal court, two motions remain pending in front of the court: the plaintiff's motion for an injunction and Harvard's motion to dismiss the case as moot. On our motion, Harvard has responded saying you shouldn't give the plaintiffs an injunction because the case is moot, and then they have also filed a motion to dismiss based on mootness. We have asserted in both our response and motion that, I should say that both motions are almost fully briefed and will be pending before the court here in a matter of days. But our basic position that underlies both of the motions is the legal doctrine that a case is not moot if there's nothing that legally bars someone from reinstituting the policy after the case. And so we are continuing on with our effort to have the court permanently enjoin the sanctions policy, because frankly, this is, and Discovery really brought this out to bear, that this is something that is just so deeply rooted in Harvard's leadership that we're not willing to just take their word for it. So I can get into a little bit more about what we learned during the course of Discovery about provide some color commentary about about how the sanctions policy came to be, and then between Zach and I, I'm happy to talk about the implications of this decision, especially decision denying Harvard's motion to dismiss may have for fraternities, single-sex social organizations moving forward. So again, Always dangerous when you give a lawyer the floor. Probably a little long-winded, but thanks. And I'll mute now and happy to take any questions.
Well, I think the first question, and the one that's very burning in my mind, is what do Zach and Clark think of this idea of sort of vicarious liability, where other people who join an organization years later, perhaps, are paying a price, or are branded as people of misconduct for actions taken by other members of their fraternity or organization, perhaps even before they arrived on campus. This is a very troubling notion. I wanted to know what both of you thought of that in terms of due process and overreach and so on. Many people felt Harvard was very overreaching. Zach, do you want to go first?
Yeah, sure. I'm glad you brought that up. FIRE deals with the First Amendment. We deal with the United States Constitution, due process, and the Supreme Court has been very clear that guilt by association is antithetical to a free society. You know, in America, we don't punish people for the sins of their parents, their children, their associates. You know, it's a very high standard. You need, you know, criminal conspiracy, whatnot, vicarious liability to really punish someone for the deeds of another. And unfortunately, at many universities, we see this happen all too frequently. We see entire university chapters, fraternity chapters, fraternity systems punished for the deeds of one member who may not even be part of the chapter anymore. For example, at Louisiana State University many years ago, they suspended the entire fraternity system based on one mere allegation of misconduct. Same with Syracuse University, suspending the social privileges of dozens of fraternities based on the potential acts of one member, just an allegation, not even a conviction or finding responsibility. So when we talk about vicarious liability, we got to really think about how universities treat these fraternities and what the legal standard is for doing so. At FIRE, through our model code of student conduct, we advocate for universities to only impose organizational liability, only to punish the chapter itself if there is culpability on the chapter level. For example, if the chapter leadership ratified a position, if majority of its members committed misconduct, or if the chapter as an entity itself, as a leadership or as its policy or as its members really broke university rules. We don't believe that when a university suspends a chapter, for example, or punishes a fraternity, really any student group, that can be justified based on the actions of one member, especially if they're acting alone or if what they're doing does not impact the chapter as a whole. So when it comes to vicarious liability, one thing that we advocate for is universities abide by the First Amendment, abide by the freedom of association, due process principles, that before you punish a fraternity, you have to give it due process, notice, opportunity to be heard, and just a basic hearing. And courts have been very clear that, you know, like any student group at public universities, for example, bound by the Constitution, that they have to give these fraternities at least an opportunity to defend themselves before you punish them or kick them off campus or whatnot. And so I think with the Harvard decision, it's a shot across the bow for many of these universities that treat fraternities like second-class groups and fraternity members like second-class students. That, you know, based on the ruling that came out, that was really a wonderful product of the North American Fraternity Conference and the lawyering there, based on that ruling that made in the motion that universities, even private universities that are not bound by the First Amendment, perhaps bound by their own policies and bound by Title IX, of course, cannot treat fraternities like second-class student groups. And I think a good part of the decision was that these university policies that treat fraternities different than other groups, that, for example, treat fraternity men male members that try to join other male groups, and of course females try to join female-only groups differently than other student groups, simply won't fly under the prevailing legal standards. So I think it's a great decision. I think it's really going to help FIRE and the North American Fraternity Conference and our advocacy for these groups, and hopefully it pays a lot of dividends in the future.
Mark, do you want to also talk about the vicarious liability, and perhaps that will get you into dishing about some of the discovery dirt you found?
So yeah, I didn't think it's actually the place to start. And that's that, it was very clear to us beforehand, just in interviewing potential clients to bring the cases, and then eventually reviewing discovery that we exchanged with Harvard, that they didn't really care about the issues that you raised. They didn't really care about the guilt by association issues that you raised, Robert, about, well, why should I be punished for something that may or may not have happened 15 years ago or 5 years ago when I wasn't a part of the club or the group. It was more that it had become a part of the DNA of Harvard's leadership, the board, the trustees, and the senior staff leaders, including Dean Carana. And there was a change in presidency in the time of all of this. Interestingly, the new president's a fraternity man, and so is his son. But you could say that they decided to pursue this policy and were so dug in because, in their view, a single-sex experience just didn't comport with the ideals that they had for student life at Harvard, and they took the step of attacking these organizations that were off campus and taking away rights, or privileges from students that you mentioned at the top of the show here, that may seem minor to some, but in Harvard life, those are all really fundamental, sought after privileges, and so the sanctions policy had some serious teeth. I hope that's an answer to your question. Do you want to follow up, or is that sufficient?
Well, do you have anything specifically concrete that came out in the discovery that really drives your point home?
Yeah, well, about 1,000 pages of email, so that get at exactly the point that I'm saying. I mean, I don't have those to put up here on the screen, but I can tell you that it was very clear to us that this had become part of the I said earlier, embedded in the DNA of the staff and volunteer leadership, and I really mean that. I mean, they were seriously dug in on this policy, and they were not willing to back down, essentially, until the Supreme Court's ruling in Bostock made it clear that the Supreme Court used the exact rationale, legal rationale, in that Title VII case that we did in beating back Harvard's motion to dismiss in federal court. And that's that just because it applies to men and women, you still have to look at the gender, and therefore it can be discriminatory. I mean, obviously that's a short version, but that was the first indication that Harvard was willing to undig its heels and rescind this policy. And in fact, in the president's press release, he mentions right in the heart of it, the Supreme Court decision that I'm referencing. So there was. I can also tell you, Robert, from the discovery that it was very clear that this was the end will justify the means endeavor by Harvard. They started off with a result that they wanted to reach, and that was no single-sex social organizations. And they changed their rationale for why they needed the sanctions policy probably a dozen times. I mentioned in my first sort of comments that it started off with men. There's some indication that it may have even started off with only final clubs because of their outsized sort of social footprint at Harvard versus the national fraternities and sororities too. And the policy and the rationale kept changing every few months because the means were changing along the way to justify this end that the leadership so badly wanted to achieve. And that's no single sex organizations at all. So.
Okay. Well, I think we ought to spend a moment talking about how Cornell and Harvard are alike or different. I mean, I'm willing to confess that many people think that Cornell has an inferiority complex, and if something's done at Harvard, it's something we should emulate and so on. So when this whole controversy erupted, I became sort of alarmed. But it seems to me there are a couple of quick differences. One is that at Cornell, most of these organizations like fraternities and sororities are residential-based organizations, whereas Harvard, they have their colleges where you live and study, but fraternities and sororities are more really sort of social organizations. They don't have living facilities. The final clubs do not have living facilities. They have eating facilities, and that's one difference. The other difference is that Harvard is a private university that presumably made representations and perhaps contracts with the students to assure them of a certain level of rights, whereas Cornell is a hybrid university where at least 4 of the colleges are members of the State University of New York, and they're subject to the US Constitution, state action under the First Amendment. And then I guess Cornell has never been willing to take that extra step and say, we'll give ILR students constitutional rights, but then in the next breath, we're going to take them away from art students. So they've always given all the students the full spectrum of constitutional rights just because they didn't want to admit that they were going to shortchange half their students. But how Zach, could you reflect on that? What are the sources? I know that the Harvard action was both a federal action of constitutional dimension, but also was under the Massachusetts, I guess, EEOC kind of statute. What are the sources of the rules that aggrieved fraternity men can run to seek a high standard of conduct from their university?
Yeah, sure. At public universities bound by the First Amendment, for example, my alma mater, SUNY Binghamton, upstate New York, they have to obey the Constitution, First Amendment, 14th Amendment, due process, all that good stuff. So if these universities violate the rights of their students or their faculty for that matter, the students can make a First Amendment argument. The argument's directly influenced by the case law, by the Supreme Court, and they can use that to vindicate their rights. And many of these state universities have been sued under the First Amendment by students and for due process issues as well, for violating their rights. At private universities, it's a bit different, it's a bit trickier. Private universities are not bound by the First Amendment. They are completely free to make the rules they want regarding free speech and due process generally. However, the vast majority of private universities across the nation do promise free speech right to their students. This is because at American universities, the free exchange of ideas is considered to be within the fabric of the university. It seems to be a part of the university's mission statement. The purpose of universities to expand knowledge and to allow students to explore a diversity of perspectives. So most universities out there will promise students free speech. There's a small minority of schools that put other values above free speech. For example, religious schools can put adherence to their religious faith above the values of free speech, which is totally fine. They have that right to do so. And all fire asks that they make that clear to their students, that when the students enroll at university, that their First Amendment rights, the free speech rights, just aren't the same as at public schools and many private schools. At private schools like Harvard, the university's policies, their student handbook, their public available documents, many courts have held form a legal contract with the students. That is, when the university violates these rules, so long as they're explicit and clear, a student can potentially win a breach of contract claim with the university. Same with due process cases. Each state's different, each university is different. It really depends on the state law and the policy, but generally many university handbooks have been held to be binding legal contracts. So, for example, if a private university like Harvard violates a student's right to freedom of association, it's specifically clear in the university policy that this university will promise students freedom of association. That student could go to Harvard and say, hey, you violated this right that you promised me. And that's what a big part of FIRE's advocacy was saying, look, Harvard said X and did Y. They said they promised A and delivered B. It's like if you go to a university and you pay 60 grand for tuition, and they say, all right, thank you for your money, but we're not going to give you any classes. We're not going to give you a dorm. We're just going to say, thanks for your money, but bye-bye. It's kind of the same kind of concept of breach of contract. It's violating the promises to their students. And a large part of FIRE's advocacy is asking universities to uphold their promises, to stand by their promises, especially nowadays when universities have a lot of pressure on them to violate the rights of their students, to create a diverse and inclusive environment, sometimes at the expense of free speech rights. FIRE has always advocated for universities to talk the talk and walk the walk. And if you're going to promise free speech, if you promise due process, let's uphold these values when challenged.
Clark, could you also elaborate on that? And in particular, what I don't understand is how much if I'm running for the captain of the football team and I'm a member of a single-sex organization, how much due process do I get when the question arises whether or not I'm eligible to run for the captain of the football team? As applied, where did the anvil fall on students' heads and so on?
Well, so there's 3 points. One, as to Harvard, the Massachusetts Civil Rights Act applies the rights contained in the Bill of Rights to the institution. And so it's a private institution, a purely private institution, but the MCRA applies the rights to the Bill of Rights. So, that you're going to get 14th Amendment due process. What Zach said a minute ago, you get notice, you get opportunity to be heard, and you have the right to a meaningful appeal. And of course, that's very high level, but in the case of Harvard, you get exactly what the Constitution provides. The second point is that in other cases where there's not a state law that provides that hook, in fact, I'm not aware of many. I'm aware of the Leonard Law in California, which applies certain First Amendment a hook, so to say, on First Amendment cases to private institutions. I'm aware of the MCRA in Massachusetts. But in the absence of that, you're really going to have not a due process type claim, but a claim based primarily in breach of contract, as Zach was describing earlier. I will say that sort of one of the disheartening things, I mean, he gave you sort of the upbeat, let me give you the downbeat, and that's that while you can you can theoretically make out a breach of contract claim against a private institution for not following their rules, most of them can also change their rules in the way that they please. The caveat to that is that some, and I think this will hit close to home, Robert, if I'm not mistaken, some by their code set out rules by which they have to follow to change their rules, and so you get a little bit of a chicken and the egg type situation. But in the absence of that, and let me tell you that many private institutions don't have rules to follow when changing rules. They can go and they can change their code when you want, and you're not going to have any sort of breach of contract claim if the activity in question is prospective in nature. Now, if they violate the rules on the book, then you can try to make out a breach of contract claim. Of course, then your case is going to be subject to all of the normal potholes that any case is. You're going to have to prove, what's the causal link, what are the damages involved, how foreseeable was the conduct in question or the damage in question to the bad actor. And those are not I'm not talking one specific cause of action, but just bringing a lawsuit in general. And so, I think that's what I would tell you. In Harvard, we were particularly benefited in the state court case by the Massachusetts Civil Rights Act, which made Harvard subject to the protections of the Bill of Rights. Now that didn't affect, of course, the federal case, which was primarily based in Title IX.
What about how it was applied? I mean, for example, the Harvard Crimson is a student organization, but they argued that somehow they should be exempt and be able to pick whoever they wanted to for their leadership. And they got a pass where some other organizations didn't.
Well, this one's pretty easy. I'm not aware of that policy being applied to anybody. So they kept delaying it and implementing it in a, oh, it's going to apply to, this will be the first class it applies to, the class of 20, let's see, I have to do the math real quick. The class of 2023, say, and then by the time the lawsuit heated up, I'm not aware of any students saying I missed out on my Rhodes Scholarship faculty endorsement because of the sanctions policy. I think between COVID and the lawsuits that it got nipped in the bud in the nick of time. It could be wrong about that, but of course, I'm not aware of everything that goes on in their campus. But I'm not familiar with any cases of the policy actually being applied.
That's right.
Zach, maybe, but okay.
All right. Well, the other question is, what was the underlying predicate? Was this policy really designed to? Some people said it was designed because sexual assaults were somehow correlated with membership in single-sex organizations, and some people claim that finals clubs and so on were guilty of alcohol abuse or excessive drinking, and that this was, some people at Harvard claim that this was really a device for addressing alcohol issues or sexual misconduct issues, and that it just all was a way of trying to address those problems. To what extent do you feel that was a valid rationale, and if hypothetically a campus has a sexual assault problem or a alcohol behavior problem, how much leeway and latitude does the university have to address that problem through novel techniques and indirect regulation?
So let me answer the first part of that about Harvard specifically, and then I think Zach might be best suited to sort of answer the university latitude question. That sounds right up his alley. But let me just sort of address the Harvard piece first, and I may just take a little liberty here and tell you a story that is short, I promise. That I was traveling for work, and sometime after we had filed the complaint, but before things had gotten to, we hadn't exchanged a lot of papers. It was early on, and I couldn't sleep one night, and I was in a hotel room, and I had on ESPN, and all of a sudden on ESPN, some of you may be familiar with the 30 for 30 documentary series. An episode of that came on about the history of Harvard football. And I was, sort of like, oh, okay, well, here I am dealing with this Harvard litigation, so I might as well watch this. And they started, and this is, I'm not going to get the dates exactly right. It was about 100 years ago. And they start flashing on the screen Harvard Crimson headlines from the time of, these overwhelming majority faculty votes about how football had to be banned. It was going to be the end of Harvard. It had no place at Harvard. It didn't fit in with Harvard's ideal of the proper way to live a college life. And I just thought, we shouldn't be surprised by what they're doing here. They've been doing this for 100 years. They have been, at the leadership level, very active in social engineering for 100+ years. So why are we surprised? And that's exactly what it was. Did they have concerns, probably valid, about various health and safety issues? I have no doubt about that. Those are issues that we also take very seriously, and I wouldn't attempt to diminish an administrator's view on those things especially when he or she's the one who's living it day in and day out. So I wouldn't attempt to diminish those purported, issues that they were facing on their campus. I just can't say one way or the other. What I will say is that it was very clear that what was going on here was overwhelmingly because what Harvard did not want was single-sex organizations, and they were willing to justify the policy by any means necessary. Our friends from the Final Club will tell you that they hired an independent analysis of some sexual assault statistics that the college had cited as a one-time rationale, now backed down and withdrawn by Harvard from the public eye for the policy. They hired an independent analysis that completely debunked the statistics that Harvard was citing. Now, even they would tell you that it's not, no college campus is going to be free of sexual misconduct or alcohol misconduct or abuse. So it wasn't that, but it all goes back to what I was telling you about the ends were to justify the means. They were willing to do it by whatever means possible. And really, I sort of had a full circle moment when I was there watching that Harvard football episode. And I'm pretty sure it was a 30 for 30 that, they've been doing this for 100 years and they're going to keep doing it.
Yeah, Clark, that's a great point. I watched 30 for 30. It was startling, the attitudes back then 100 years ago. And it's just crazy how you saw that right after you filed litigation and everything. I just want to comment briefly about Harvard as an institution. I'm sure many people here are surprised to hear the leadership of Harvard is a bit self-righteous in their policies and in their initiatives that they go for. One of Fire's initiatives when we heard of this case was to take a deep dive into Harvard's archives. And we found that this blacklist policy of punishing students participating groups is not a new thing. You have the football team 100 years ago, 1920s, Harvard prosecuted gay students for their affiliations. In the 1950s and 60s, it was communist. And today it is college fraternities and sororities and single-sex organizations. It's not the first time that Harvard has made their displeasure known towards disfavored groups. To be, whatever, I guess, the soup du jour is of the year. And I think one of the most damning statements that Harvard put out during litigation, it might have been during discovery, might have been beforehand, was that this policy was designed to reflect, in Harvard's view, the attitudes of 21st century men and women. That they saw that these punishments inflicted upon students joining these groups, the groups themselves, were designed to kind of mold the ideal student towards a society that's more diverse and inclusive that doesn't involve these sort of organizations. And, as someone that was in a fraternity, as someone that, plays poker every Tuesday with a group of guys, I'm very offended by the idea that we can't have organizations that only have, just men or just women in them. So I thought that was pretty damning on Harvard's part, and that was used very effectively by plaintiffs in this case to make their case. And I think one of the really amazing effects of the decision was that Harvard as an institution, it's very prominent, very prestigious. The saying is that when Harvard coughs, all universities across America catch a cold, right? They look to Harvard for leadership and whatnot. And I know when this policy came out, universities like the University of Rochester, Baylor University across the nation were considering similar policies that they could use to also punish their single-sex organizations and the students that join them. And based on the great efforts of Clark and his team, these universities are now either shaking in their boots or quickly rescinding their policies to the benefit of students' rights across the nation.
All right. Well, we want to open it up to questions. If you go to the participants panel and quote, raise your hand, we'll call on you. But we do want this to be broadly participatory. So please feel free to raise your hand. And Art Spitzer has raised his hand. Art is an alumnus of Pi Lambda Phi. Go ahead, Art. Unmute yourself.
Thanks for the reminder. Yes, Pi Lambda Phi at Cornell. So I want to drag you all the way back to the beginning, talking about vicarious liability. Zach, you ran through a bunch of Supreme Court cases, and I think they all had to do with criminal liability. And then you talked about what FIRE advocates in terms of civil vicarious liability in a university context. But I was curious, I guess this is a lawyerly question, is there similar law on the civil side? My impression is that vicarious liability is certainly not unknown in the civil context. Employers are liable for the torts of their employees, for example. So is there anything more than advocacy, which I agree with, but is there actually any law that you can bring to bear in those cases?
Yeah, thanks for the question, Art. I definitely appreciate the lawyerly question. Reminds me of being cold called back in law school. Good times. Yeah, the standard of liability that we use in our model code of student conduct is drawn from the federal labor law. It's the kind of law that the U.S. government and prosecutors use to, I guess they did use to go after labor unions when they engaged in racketeering, all sorts of stuff like that many, many years ago. And we think it's a good standard because it really requires a level of organizational liability and a level of, I guess, policy formation and leadership culpability when it comes to prosecuting these organizations and finding them guilty. Unfortunately, there's really not that good law, and perhaps Clark can help me out with this, about vicarious liability and culpability on the student group fraternity level. You know, I couldn't find that many court cases where courts really dive into, you know, when can or can't you prosecute a fraternity or a sorority on the university level based on student misconduct charges. So all we really have is you know, the federal labor law and you know, the federal criminal law when it comes to this kind of issue. But like I said, FIRE always advocates for a higher standard. We want universities to have to prove beyond by clear and convincing evidence that these student groups committed the misconduct and give them all the trappings of due process, ability to defend themselves when they are accused of doing so.
Just to chime in here. So the point is that people do things every day that could potentially be an unfair labor practice in the course of organizing unions and stuff. And the question is, when was it just a random person doing a random thing versus the union, qua union, engaging in that unfair labor practice? And there's been standards on that. But the trouble with fraternities is they really don't have the corporate paper trail that you know, General Motors might have. They don't get together on Wednesday night and pass a resolution and write down in their minutes, resolve, we're going to party on Friday night and engage in misconduct. You know, you don't see that paper trail. So Clark, explain to us when and how it's appropriate to hold the fraternity responsible for the misconduct of individual members.
So I think I need to take a little bit of a step back. And when I talk to you, to me, it seems like an immense body of case law, but I realize to most lawyers, it's actually a needle in a haystack probably. But there is a significant body of case law across the country that analyzes the duties owed by chapters and by members and by national organizations. In most of those cases, the written decisions from the court are analyzing the relationship between the national organization and the chapter. So I just want to make clear, because I've been involved in the litigation of a dozen or so of them, and there are probably, say, 50. And I've written some articles I'd be happy to share after that cite some of, you know, that discuss some of these cases. And then if you really want to dig into it, then some of those cases have string citations that list all the cases that have ever been, you know, litigated on this point. So there are some, but I do want to make clear that most of them are in the context of the duties owed to and from chapters and national organizations. But some of those cases also involve litigation with the university. So that's not, that doesn't, it does exist. I want to just sort of, as a practical matter, as a practical litigation matter, what many plaintiffs' attorneys in fraternity cases have decided to do is settle with the university before it gets too far, or the university has settled with the plaintiff before it gets too far. Most of the time, it's the former, not the latter. But there is much less court writing on the relationship, the vicarious liability of a university for the acts of its fraternity members. Now, I think that there's a strong analogy between the case law for national organizations. The overwhelming rule that has emerged from the cases that I've been involved in is that just because you have things like health and safety standards or risk management policies or trainings on misconduct does not mean that you are liable. Your national organization is liable if an individual member at the University of Alaska commits a tort. And so that's the rule that's been adopted literally from coast to coast. I've been personally involved in cases in California and New York, and so I can tell you that there's case law in both of those that get to that. It's a developing area of the law because it's started to be litigated more in the last 10 to 15 years. In fact, one of the most recent cases, and this is another thing that I can share with you, Robert, for dissemination after, is a decision from the California Court of Appeal that discusses the vicarious liability that flows between IFC officers and individual student bad actors. So that the universe of this law is expanding little by little, but I think that, any litigation that you could possibly imagine in the fraternity or sorority context is going to have strong analogies between the things that Zach mentioned and then the things that I mentioned.
Well, isn't the real problem that once things get to the litigation stage, once the misconduct gets to litigation stage, generally sort of the insurance company takes over the defense. So it's really the insurance company's judgment as to how strong a case there is for holding the fraternity, the insured entity, responsible for the particular example of misconduct.
Well, it's a keen question, and I'll just, sorry to cut you off, but I know where you're going. So it depends. The answer to that is it depends on how the policy is written. I have worked with different fraternities who have slightly different defense clauses in their liability policies. Some are going to have turned over all the control to the insurance company or the third party administrator, and that third-party administrator or the insurance underwriter is going to retain all the authority to settle claims on behalf of the insured. Others have, and most of the time, frankly, these are ones with cleaner loss histories that have the leverage to demand this in their contract of insurance. But there are other contracts of insurance that allow the insured to be more involved in the defense of their claims. And so it just really depends organization to organization. However, all that was like word salad, and I totally understand that. That in the grand scheme of things, the small handful of liability insurers in this space for fraternities and sororities have a significant influence on the way the cases are resolved. Yes, I mean, so the answer to your question is correct. That you are correct, but I think that it really does depend on the organization and how their policy is written.
All right. Well, I don't want to be bashful. Oh, Bob Linden, are you raising your hand? Go ahead and ask a question, Bob.
So it's a little off the subject, but important to Cornell. I'm Sigmund from Cornell. We were suspended in 2018. During the process, we found Cornell doing two very bad things, one completely illegal and one unethical. And we were told exactly what Zach said. Basically private institutions make the rules, enforce the rules, and hand down the discipline and cannot be challenged. And so we did not proceed. As many on this call know, some of the rules at Cornell become quite onerous. My question is this: we have a lawyer We have a alumnus at Cornell who's undergrad Cornell, law school at Cornell, who does a lot of Greek work in Ithaca. And he's advocating that fraternities de-recognize, that they drop their recognition from nationals, and that would get them out of the onerous rules of Cornell. Now, Cornell, I've been told, requires fraternities, if you have a national, you have to be registered with that national. But this lawyer feels that we should jump on the bandwagon and just all, disassociate from our nationals and become locals. Does that work across the country, number one? And is it even possible at a private school?
Let me just, since I came, before I was general counsel, then I was general counsel of a national organization with a couple hundred chapters. So I've dealt with this a lot. I'll tell you that most often it does not work. A lot of people try, and even more mention it. It doesn't, it's sort of a half-baked idea, frankly, in my opinion. I'm sure the person you're working with has justification for his opinion too. It's very hard to obtain very good liability insurance as a standalone private organization. And then in the case of litigation, insurance issues aside, without all of the guardrails provided by the national organization in terms of risk management policies, I have significant exposure and liability concerns for undergraduate officers and for advisors. But those are sort of the legal technical responses. On a practical matter, I've seen a lot of groups try it, not just from my organization, but from organizations across the country. And I'll tell you, this is the normal lifespan of it. It goes strong for a couple of years. The alums and the students are excited about it. Things rock along as usual for a couple of years, and it falls off a cliff. Because those people who are real gung-ho about it to start with, they go away, they graduate, they have a kid if they're an advisor, they have a second kid, they have a kid go to college, whatever. You name it, it happens. And the support for this has a distinct, precipitous drop. Is that true in every case? No. I know of a few people I know of a few groups and a few spots in the country who have relinquished charters and become successful local independent organizations. If I were your lawyer, would I advise you to do it? Absolutely not.
Yeah, I don't have the same experience as the depth of experience and knowledge as Clark on this issue, and I definitely trust his judgment, above, what FIRE could provide. But just on a basic level, most universities do not allow student groups that are not recognized by the university to have events on campus, to recruit, to advertise, to use campus resources at all. From a practical level, universities tend to require student groups to be recognized by the university. And like Clark said, that usually requires a connection with the national chapter as well to operate on this campus. And perhaps one of the reasons that Clark mentioned about, the precipitous drop is that without the ability to recruit, to utilize campus resources, to be part of, the campus IFCs and to really have events on campus and be part of that community and to really talk to students on campus, it's difficult for these groups to develop the infrastructure and the resources to survive many years beyond, like Clark was saying, that turning point, the tipping point where people just don't want to do it anymore.
Thank you.
We have other questions. Either raise your hand electronically or wave your hand in front of the camera. Okay. Well, why don't we give, Bob has another question.
Coming back to what Zach said about defending your rights and then, in the midst of doing that, defending other people's rights. On fraternities across the country, when you do that on a campus sort of like Cornell's, which is coming down sort of hard on the Greek system, do you put a target on your back? Have you found that now you're that outlier to the university, the university administration, and they're going to be looking at you if you're sort of rocking the boat, rattling the chains, and trying to bring these things up, in free speech? Do you feel that behind closed doors, you really do get a target on your back for future relations with the university?
That's a good question. I have to respect that question. Many of the student groups and the students we defend are very strong-willed, very outspoken. They don't fear the consequences. They're gung-ho. They want to defend their rights and, kind of stand up and, fight the power a bit. And so it's definitely not for the faint of heart. And I respect the idea that, when you do this sort of thing, when you tell the university that they're wrong and that what they're doing is illegal, the university can sometimes respond negatively. They can sometimes retaliate against the students. That definitely happens. At the same time, though, I feel like universities treat students like they're transient because they're only there for a number of years. And they think that if these students are new groups simply just, kind of just get their degree by their time, they'll just kind of go away. And I think that's an extremely detrimental attitude towards students' rights. And that if these students, do fear that they would have target on their back and that they will never be able to, vindicate their rights and up for themselves, it really sends a message to the university they can do whatever they want. Sometimes all it takes is just one student group to say to the university what you're doing is wrong, it's illegal, to blow the whistle, to contact, Clark's group and fire, and really kind of put the screws to the university and say, look, this is not okay. This is about the rights of everybody here. It's about the bigger principles. And I think that you're right. It does take a very strong-willed, courageous student group or student to do that. When it does, it benefits for sometimes generations of college students.
So let me just add one thing, and this will bring it full circle to Harvard. When we were recruiting plaintiffs for the federal case, individual plaintiffs, you will notice if you read the complaint for the Harvard case that they're styled as John Doe, and we asked the court for permission to do that. And the reason why is because those students wouldn't agree to be plaintiffs without the protection of the pseudonym. And so this is an answer that is necessarily Harvard centric, but I think it's just you could take it so take it for what it's worth. But they were in the process of litigating the pseudonym issue. We asked Harvard if our students were to unmask and proceed under their names, would they agree that as to the plaintiffs, they would not enforce the sanctions policy? And believe it or not, in the most baffling decision of the whole litigation to me so far, Harvard's lawyer said, no, we won't agree. We won't agree. We will apply the sanctions policy even to the people suing us to strike it down as illegal. And so if that doesn't tell you how dug in they were, I don't know what will. And a decision to this day that can't be seen as anything but anti-student. And they don't care. They really don't care because it didn't fit their idea of what social life at Harvard should be. So yeah, it's sort of a full circle moment, but I think it gets to the point that students are very much concerned about retaliation. Yeah. And we have to do everything we can.
Can I extend Bob's question in terms of retaliation from other students? We hear a lot about cancel culture and people going on change.org and starting petitions to somehow shame and go put social ostracism against student X or student Y or student group X or Y. To what extent in this sort of cancel culture do you find fraternities being targeted, perhaps being falsely characterized as being white privileged or what have you? But to what extent do you see that today? Zach, do you want to go first?
Yeah, your question reminds me of this case that we're working on against Florida State University, which has a student government that's larger than most municipalities in Florida. It's like the budget is like $2 million. Its jurisdiction is like 50,000 students. It's a massive student government. And one of the provisions they have in their campaign code of conduct is that students should not demean or attack or offend other campaigning students. And we wrote Florida, we said, look, if these students are being trained for leadership in the United States, they're being trained for political leadership in our country, they have to be able to endure really just caustic, venomous attacks against them, because that's what being a politician in America entails. That's what the students are supposed to be prepared to learn and to really endure and to counteract. And so we see a lot of cases where students come to us and say, I'm being attacking social media. Students are saying bad things about me. My fraternity's being, dragged to the mud in the student newspaper. And at FIRE, we have to advocate that the best response to speech that you disagree with, the speech that is offensive, is more speech. You have your ability, your facilities to debate, to discuss, to prove people wrong. Students should be taught that the answer to censorship is more speech. It's not violence. It's not lawlessness. It's the ability to use their own facilities, their education, their knowledge, really, to make the best case for themselves. So there's definitely a lot of anti-fraternity sentiment going around here, but I think that based on the statistics and based on the facts of fraternities and all the good they've done for society, and just a general success of their chapters throughout the nation, which I'm sure Clark can attest to, I think they have a really, really good case for proving their worth and for using their own speech to counteract this negative sentiment.
So yeah, just a couple brief comments, because I know we're getting pretty long here, but I personally have decided to move away from using the term cancel culture. I think that it probably misunderstands today's college student, how deeply and how fervently they hold some of the beliefs that they do. And so I try to think of it more in terms of justifiable concerns of what's going on in their community. And we need to train ourselves to hear them and to understand them. So I've sort of, and people in my circle, we're trying to move away from amplifying the use of that term, and instead talk about it more in terms of justifiable concerns, because what we have found, with all due respect to everybody on the call, is that many of our advisors don't understand today's college student very well, and don't understand the reasons they have the concerns that they have, and they don't understand just how deeply they hold those concerns. So with that in mind, I would tell you that on about 30 campuses right now, there are movements to abolish Greek life. That's both fraternities and sororities. There's a movement, they have a name, they have a website, they have an Instagram account, abolishgreeklife.org. And, Cornell is a prime target. I wouldn't be surprised if it pops up there in the next 2 months. It hasn't gotten a lot of legs anywhere, but yes, I mean, there are, what you're talking about, this sort of social movement that we're seeing in the country on other issues is absolutely bleeding over to both fraternities and sororities. And it's going to impact a lot of campuses. It really is. And I will tell you that often these movements, the Abolish Greek Life movements on these campuses, are being led by our own members. And so it puts us in a very tough position to combat it. So the answer is yes. And I just want to sort of tell you about how we're kind of talking about it, trying to understand it. And I want to just be clear that we're learning too. So we're learning as it goes on, and we're committed to learning and to try to, in our advocacy work, not only defend fraternities, but also understand students.
Well, that is a very important point, and a very valid point. The tension I see is that you have students, and some of them may have a more shorter term time horizon than alumni, and alumni are sort of worried about investment in physical plant and fundraising and very long-term issues and protection of their quote investment to date, whereas students are always looking for, how can I best apply my life and build my legacy at the institution and so on, and there are just inevitable tensions between those two different avenues. And it's funny because we're talking about vindicating the rights of association of undergraduate students. It's their rights we're spending all this time and energy for. Yet, that may be inconsistent with what the alumni leaders might want to do in terms of their protecting their institutional investment.
Well, there's certainly some tensions in the issues that you raise. There's no doubt about it, and they just have to be navigated very carefully. But what we've found is most important in sort of dealing with the campuses that are facing these issues is to really try to get the sides, everybody involved to listen to each other, and not we're so right because we're students, we're on the ground, or we're so right because we have a longer view than you and we put all the money in the house, and therefore so that sort of digging into the sides of things doesn't make resolution easier. It makes it harder. So what I sort of preach to everybody is we really have to listen, and frankly, as the older folks, the advisors and the professionals in the industry, we need to be even more patient and listen a little bit more than our instincts would tell us to.
Art, did you raise your hand a second time, or are you good?
No, I did, but if we're over time.
No. I think we have time for one more question. Go ahead, Art, please.
All right. So I raised my hand while Zach was speaking, and then Clark really anticipated my question to a fair extent when he started talking about the movement to get rid of fraternities, to get rid of Greek life altogether. But my question was, and is there any reason why a university couldn't abolish Greek life, a private university first, and then, would it be any different for a public university because of constitutional freedom of association issues? But could Cornell, just for example, say, we're not going to recognize fraternities or sororities, and that means they can't hold events on campus, they can't publicize their events or their rush using campus electronic communications, stuff like that.
Clark, why don't you go first?
Yes. There you go.
Yes, there is a reason why they can't. Good.
Sorry, no, they're a private institution, and they can recognize the groups that they want. What they can't do, and where the line is drawn, is Harvard. When you try to regulate the association of groups that you do not recognize, and that's what Harvard did. That's what drew him a lawsuit. But if a private institution wants to say we're not going to recognize fraternities and sororities, they can certainly do that. So can a public institution. Title IX provides an exception to the schools for recognizing them, but it doesn't say they have to. So it's a little bit of a trickier analysis with the public school because of the association. They can't forbid them from associating, but they don't have to extend recognition to them. Just like they don't have to have a men's golf team.
Well, what does recognition mean? I mean, how do we separate that from, 30 guys renting 2 great apartments in College Town off campus with a very thoughtful meal plan and programmatic aspect, social, service philanthropy. It's sort of a slippery slope. I mean, Telluride, Cornell's got the Telluride House, which is a scholarship house. It's private. Is it recognized by the university? They're allowed to recruit students to live in for 4 years. It's a room and board is paid for. So I just don't, I'm not sure I understand the concept of recognition. I've been promoting the concept of the value of the small residential experience. Just get rid of the term fraternity for a moment. It's hard for anyone, administrators or others, to deny the value of a more intimate connection to 30, 60, 80 people to experience their 4 years. It was mentioned briefly before, most students experience college as nomads. They move from place to place. Imagine trying to get through high school with your family and having to move residence every year. But a year later, they don't have that connection. So I'm really confused by just this concept of quote unquote recognition.
Well, that's because it's a bit of a nebula. I mean, it's because it's a bit of a gray concept, and the universities are going to be given pretty significant latitude to decide what it means. That's just the way it is, especially a private institution. But recognition, I will tell you, in many places, recognition is defined by recognition agreement. pardon me, and that's going to provide the push and pull on both sides. What does a university give to the chapter, and what does the chapter agree to do in return? It's things like meeting space, on campus, or certain benefits related to IT, or the list goes on and on that the campus is going to give to the university, and to the chapter. In return, the chapter agrees to abide by a certain set of rules. That's the paradigm of recognition.
Yeah, I was going to say, I reiterate everything Clark said about, schools abolishing fraternities generally and whatnot. Schools have the authority to control which groups they recognize. Some limitations on that are, for example, content regulations. For example, a university would not be able to recognize the college Republicans, but not the college Democrats. We have a lot of cases with viewpoint discrimination. Universities cannot discriminate based on which groups they recognize based on their viewpoint. For example, you have a famous case, university didn't recognize a group advocating for medical marijuana. It's a very clear withholding of benefits based on a student group's viewpoint expressed. The issue with fraternities is that they're mostly social organizations, in that they don't, their mission statements don't involve a set of political or religious principles. They're simply there to, kind of like the Elks Club or the bowling league, to have the social groups, which is great. Nothing wrong with that. Unfortunately, under the First Amendment, that deserves a lesser form of protection when it comes to university recognition. If a fraternity, for example, was a Jewish men's organization, that would be a different story, in which case university would have a difficult time failing to recognize them while recognizing the Christian Interfaith Fellowship, right, discriminating based on religion and whatnot. But like Clark said, as long as the policy is content neutral, as long as it's done in an even hand fashion, I would say even a public university would be able to refuse to recognize the whole category of Greek organizations.
We give each of our speakers just 1 minute to wrap up and summarize, and we'll hold you to your promises to send me the links that I'll send out on the matters we covered so far. But if Clark, do you want to just have a few final words of wisdom?
Yeah, well, the wisdom, you get what you pay for. So I'll just tell you that, I really appreciate you guys having me. Thanks for all the engaged questions, and really sort of shows that you guys have thought about the issues deeply and understand and care about them. So, thank you for being involved, and thank you for caring. There are organizations out there like Zach's and mine who are sort of in this fight every day, and we don't ever, we don't talk to folks like you every day. So it's good to see, the people on the ground who are really doing the real work, and we're at our computers all day trying to defend and preserve this experience, and in Zach's case, many other experiences for college students. So, appreciate you having me, and be happy to come back sometime. And Robert, I'll share the links with you.
Great. Yeah, I was going to say it's a real pleasure and an honor, being here, being able to have this panel. Thanks, Robert and Dan, for organizing it, and of course, thanks for Clark being here, definitely giving us his perspective and his organization. I just want to say, I really appreciate the opportunity to speak to this group of people. If FIRE can be of any assistance to any of you, definitely feel free to reach out at, thefire.org. We have a website. I'll even put my email address in the chat. So you can email me directly. If you have any follow-up question, anything we can do for you, definitely reach out to us. We always love to hear from people that are interested in our issues: free speech, students' rights, due process, all that stuff. It's important to us that we have this group of people that, believe in these issues, that, are willing to fight. So like I said, thanks again for tuning in. Thanks for the questions. And I hope to see you guys soon.
And thanks to both of you, and thanks to all of our audience who have participated. And I do deeply appreciate those of you who asked questions. And I hope that we can do more of this. I think there are a lot of issues that are of interest, and I hope that John Yerger and the Alumni IFC will find more common issues that we can bring to the wider alumni leadership. And again, thank you, Dan, for hosting us on your wonderful Zoom account. All right, so we'll adjourn the meeting now. Thank you very much.